I think we need to take a long-term perspective to litigation support. Whether an independent consultant or an employee of a company, an expert witness must still act as a team player. You will work with at least one attorney on each case. You will meet with the client or colleagues that work with the client. And you will meet a host of other support personnel and even other experts who may have been retained to help with portions of the case. You have to not only bring your expertise to the table, but you have to bring the same charm, smile, warmth, and friendliness that you may show to a jury or a judge. Of course, let's not forget that you may have this expert witness role as a side job for decades, not just 1 or 2 times. If you are useful, your first case will turn into your 10th or your 100th. Attorneys have hired me as an expert in well over 100 cases since my first case in 1986. Having expertise then served me well, but maintaining that expertise has served me well since. You must maintain your expertise and stay current in your field. This should include attending conferences or seminars, reading appropriate journals, books, and other treatises published in your field, and staying abreast of the latest developments in your specialty. Let me take a few moments and talk about legal jargon. Lay witnesses are individuals who have first-hand knowledge from directly seeing or hearing something. You, as an expert witness, will look at material or interview individuals or reconstruct events, and then testify about what probably occurred. Your expertise, followed by careful and methodical work, qualifies you to present an opinion about an event that happened when you weren't even there. The court does not have to accept or believe what you say. Remember that. You must convince the jurors or the judge of the believability of what you say because of your expertise and your workmanship. You should also understand the meaning of privilege in the United States. Privilege protects conversations between attorneys and their clients. Attorney-client privilege exists in the law to foster open communication between clients and their attorneys. Because neither the attorney nor the client has to reveal the content of their discussions to the other side of the case, they can both feel freer to have honest discussions with each other. You, on the other hand, are not a client. So what you say or write to an attorney about a case does not have this protection under the law. The laws on privilege do vary among the states, and at times may even vary between those states and federal courts that apply federal law. When an attorney retains you, you should have a discussion with them about privilege, because you must understand privilege fully as it covers communications, both written and oral, between you and the attorney. You do not want to become a liability to your attorney or his client if an opposing attorney asks you about what you knew, know, or said. Attorneys may hire you as an expert to help them in either civil or criminal cases. The rules of law differ. You should ask the attorney that retains you to explain the laws involved and how your opinion and work will tie in to any relevant law. Criminal cases often end in a jail term, while civil cases often end with a financial judgment. You serve the same role as an objective expert in both styles of case. You have to analyze and explain facts in such a way that you both help the lawyers to do their job and help the court to determine the final verdict.